Good afternoon, everyone. My name is Baldev Binder. I am the Managing Director of Blackstone & Co. We are an energy and commodities law firm based in Singapore, specializing in international trade. The work we do includes trade finance, trade structuring, trade investigations, and trade fraud in particular. And that's what leads us quite neatly to the topic for this afternoon, which has to do with the trade defaults that happened predominantly in 2020, but from my perspective, has been happening for the past several years now in the first instance. I want to speak candidly about some of the issues we see, but at the outset, I think it's quite important that I stress that there are no names going to be mentioned of cases being worked on. What we've produced in these slides are themes drawn from cases that we've seen, drawn from real life examples. We make no reference to any case. None of this information provided has been obtained from court documents. All of this is obtained from public sources, and it's all within the public domain. The value I hope to give you within the next 45 minutes really is to distill what are the key themes that have run through several of these cases, not just last year, but over the course of a couple of years, starting all the way from 2015, effectively, when we started seeing our first wave of trade defaults in commodities. I'm going to start with some of the themes that we have come across. So before I launch into this, I have a bit of a story, a bit of a personal story to share with you about myself. And I think it will lead into what I want to share this afternoon. My great-grandfather came to Singapore in the 1920s, I understand. And he came to Singapore and with no money, as most people did back then, and he started selling textiles. He started selling textiles off the back of his bicycle and made, a bit of money that way. I'm given to understand from whatever money he made, he then got into the money lending business. He started lending money to a variety of people. So when I was a child and my dad told me, oh, your great-granddad, that's what he did. But the first question I asked is, who exactly was he lending this money to? And it turns out, what I'm told, it turns out that he was lending money to borrowers so that they can repay other people, they can repay banks or institutions. And so it was more the case of getting cheap financing or cheap lending to repay other people. I say this interestingly because it seems to me that 100 years has gone by, or close to 100 years have gone by, and not very much has changed. So the cases that we've seen from last year work around this theme of cheap financing and using financing from one source and applying it to another. And in this constant merry-go-round of using financing from one lender and applying it to another aspect of your business, there is this trend of over-leveraging. There's a trend of getting your gearing ratios wrong, leading to catastrophic collapses. The themes that come out from the trade defaults that have happened in the past few years are listed in the slide in front of you. And I've put it down as to 5 or 6 common themes that have have come through. The one common thread put it across all the different cases is that there is allegations or assertions of multiple financing. Multiple financing meaning the same BL, the same bill of lading, the same invoice is being used 2, 3, multiple times over and over again. This is a perennial problem that has plagued trade finance or international trade for a long time. And the reason behind it is because there is no central registry that collates all the BLs together, that puts all the BL information together. And in some of the pictorial diagrams I'm going to show you subsequently, I would demonstrate how one lender is effectively blind to what another lender is financing at the same time, which lends to an unscrupulous trader exploiting this information gaps by double financing. This space about a registry and what it is to, what's going to replicate it, sorry, what's going to fill up that role in the future is worth looking at, and we'll come to it at the right at the end of the presentation when it comes to questions. Another theme that has come across is BLs and invoices not tied to the trade. So in the first example, you take one legitimate BL, you finance it multiple times. Why do you do that? You're doing it for working capital more than anything else. You're trying to get money into the business, either to pay for an existing big hole in the company or to do more trades. In the second example, you have BLs or invoices that are just not tied to any trade, meaning that these documents are forged, they're fabricated, they have no link to an underlying trade. And this is yet another fundamental problem with international trade. And for anyone familiar with the business, documents and goods move in two different speeds, two different directions sometimes, and there is a lack of consistency, there's a lack of harmony or alignment between the movement of documents on the one hand and the movement of goods on the other. The third theme that we've seen, and this is something that might interest a lot of big trading houses, is that there are big names involved in some of these cases. And some unscrupulous traders, a fraudster who is out to deceive and manipulate and put up smoke and mirrors, is interested in using big names to cover their tracks, to give a trade a sense of legitimacy. By creating segments of buy and sell legs across a various chain of one trade, and inserting, using big trading houses, big banks in between, an illegitimate trade suddenly gets this veneer of legitimacy. And at the same time, lenders who are involved in other aspects of the trade start to take their eye off the ball somewhat. When you see a big oil major, when you see a big miner, a big trading house, naturally the concern that the level of rigor when it comes to looking at documents might just take a step back. And that's just the human psychology behind the people who look at the documents. I've touched upon documents being fabricated, but another point is receivables in particular. And I'll stress upon this topic at various times of this presentation. Receivables for a trading house, sometimes that's the only asset a trading house has. Not a mine, not a storage facility, not a warehouse. All it has are receivables, meaning what its counterparts would have to pay for goods supplied. And there is this temptation. There's a temptation to inflate receivables to allow access to working capital. Once again, the larger my receivables are, the greater my assets are on paper, the more I can borrow, the more I can discount these receivables and get hard cash. So there's an inherent temptation over there when it comes to trade fraud dealing with receivables. The last point I want to jump to, we talk about credit exposure and set off not being verified. That really is a case of bare-bottoms due diligence. I think that is essential. And I know every lender, every insurer in this business would say this is a key component of their business. And yet sometimes when you go back and you unpeel the layers of the onion, you sort of notice that the level of due diligence might not have had the same rigor or robustness that one would have expected. The last theme, and this is something that I think has become a lot more current with the recent collapse of large fintech companies dealing with supply chain financing, is the use of credit insurance. Credit insurance has become a tool in a trader's toolbox when it comes to getting access to financing. It's come to a point where now credit insurance is often wrapped around a financial product to the wrapped around a trade to create a financial product, such that at different stages, one might not even realize what that underlying trade is anymore. The credit insurance element of it seems to put international trade at times on steroids, and it's, in my mind at least, it's a misuse of credit insurance. Let's move on to the next slide. How does one do trade fraud? And the ultimate question to be asked at any point of time, whether you're onboarding, whether you're operating, executing an actual trade, or when you are in my position investigating trade fraud and trying to do recoveries, is has the trade been set up so that you get finance for a trade, or has the trade been created for finance? There's a nuance in how we put the same words in a different order, and it takes a different complexion altogether. When one is trading for finance, what I mean is the trade is being created just to get access to finance. How does one do that? It's multiple fold. And I've created this pictorial representation here deliberately, and you'll see that the trader is a lot smaller than the size of his balance sheet. A small trader can actually create a balance sheet that's 3 times its size, and it's the balance sheet that drives how much money it can borrow, how much money it can generate. And so the real test behind this now, or the real consideration, is how do parties go about increasing their balance sheet size? And they do this in a variety of ways. You know, your baseline unsophisticated fraudster, put it this way, they might dabble in double financing, pledging the same cargo twice, because Bank A and Bank B do not know that they're financing the same cargo. Then on the left side of the screen, the bottom left, you've got the practices of fictitious invoices and forged inventory balances. As I mentioned before, receivables are a key element of a trader's asset list. And by forging invoices, a trader then creates a larger balance sheet and gets access to liquidity. For other traders who actually have inventory, whether you're in the oil business, whether you are in you own cargo or material in a warehouse, for example, by forging these inventory balances, gives access to financial liquidity. At the bottom of the screen, there's also this notion of sale and buyback, often used as a repurchase agreement in trade terms. That's when you sell and you buy back the same commodity at the same time. Technically speaking, nothing quite wrong with that, but when you sell and you buy back within a second's difference, I think there are questions to be raised as to what exactly is the nature of the trade. The last phrase or the last method would be this notion of teaming and lading. And that's something that this phrase is something I've learned only in recent times. And it's an accounting term. And effectively, to put it in as simple terms as possible, it means taking receivables received for a repayment that's due today and applying it for a repayment that was due last month. It means taking receivables and applying it to an older repayment schedule. And by doing so, in the books of a trading house, you give the impression that the wheels of the business are moving. Account receivables are coming in, they are being paid, and they're being accounted for accordingly. To touch briefly on this notion of double finance and circular trades, these words are used quite often, and they have nuances within its format. Let's talk about circular trades first. In a circular trade, traders that are looking at long voyages would think, okay, I'm moving some cargo. Let's say I'm moving cashew nuts from Africa to Vietnam. That should take about 14 weeks. In this 14-week voyage, I haven't found a buyer yet. The ship is just sailing towards the buyer. Let's trade the goods in the meantime. So trader A then sells, he creates a loop of trades, all the while with the intention of buying it back. Trader A needs to buy it back so that eventually, when the vessel arrives at port E on close to 14 weeks, the trader has the BLs. And at that time, he can then commit to a sale to the buyer. In this sequence of events, I don't take too much objection to it. The trade that's being created, the circular trade, it is fairly synthetic in nature because when A sold the goods, he or she knew that he was always going to buy it back. But my objection is this. It is quite one thing to do a trade in the way I just described, and another if A has already committed to a sale today with E for a sale of cashew nuts and then created this sub-sale, because you cannot be selling two things at the same time. I put this complex looking diagram up for everyone to have a look, and it is the notion of a phantom or a mirror trade. So on the left, you have the mirror trade, the mirror meaning the fictitious trade. I think that is actually the more important trade, and from experience, that is the trade we see the most of. We see the left side of the screen, and after a bit of digging, after a bit of investigations, we find the right side of the screen, the actual trade that went on. It's called a mirror trade because it's a duplication of the same trade, goods moving to the same location, the same vessel, same container numbers, but using different party names. How does one go about doing this? It's not too hard, to be honest. It's often the case that the person starting the trade is orchestrating a movement of documents by replicating the same trade using a mirror chain of parties. For this system to work, the receiver, the parties at the end of the chain need to be, I would imagine, need to be working together. So I've got A, D, and H, who I've put as empty boxes there that are not in blocked out colors. These three parties, if they are working together, they can then create a fictitious trade by producing a BL with the same details of the cargo, same vessel name, same shipper, same different notified parties, and then pass it on by creating a new trade down the line. The question that I get asked the most is there any way you can tell when the trade, which one is the real trade and which one is not? And the answer to it is that it is really quite difficult. There's a fair amount of time and energy used to figure out where the goods went to and who had the goods at any point of time. But there are some telltale signs in the documents itself. For example, I think one of the questions when doing due diligence, when we do investigations and so on, is to ask the logical question: what is the commercial purpose, or can each party justify its commercial purpose in the chain? Often we find a party like C had nothing to do with the trade. A party like C was simply introduced or inserted into the trade by B or by D. And when the question is asked as to why C is inserted, we're often told it's to raise financing. It's to leverage on C's financing. That might make sense if C is a large company, but oddly enough, at some of the cases we see, B and D are the large companies, and C is a small company. So it befuddles, as to why C is being in the chain in the first place. And when we go unwrapping these layers, we find that the parties, A, can't justify why they are there, B, can't explain how the trade originated in the first place. They are simply a pass-through. They are what I have coined to be a conduit trader, a trader passing documents from one party to another. That increases the risk of a phantom trade. It is not in itself conclusive, but it increases the risk of it, because when you're passing documents through, that level of being able to identify, verify, authenticate the documentation and the goods is just not there. There are other telltale signs in the documents as well. For example, every trade comes with, or most trades come with certificates of origin, and these are needed for export purposes, for import purposes as well. And you find that parties that are, for example, there are cases where I've seen an exporter, the certificate of export or the certificate of origin would list a Singaporean party for an Indonesian export, and you sort of wonder, how can that possibly be? The exporter has to be an Indonesian company for regulatory reasons. And then you start to wonder whether these documents are legitimate or not. Likewise, for the concept of the shipper. The shipper, for most part, tends to be the same as the exporter. So you want to reconcile some of these very, very small clues in the documentation to try to see whether there is anything suspicious about the trade. Because if not, you would find that in the investigation aspect, what you thought was the left side of the screen becomes the right side of the screen. What actually happened is that the goods did not go to B, C, and D. It went direct to E. E then sold it onto its own chain. And we often find by the time the goods were discharged, the goods were discharged well before it even got to any of the parties in the phantom screen on the left. I'm going to touch on oil trading in particular, and I think those in the market we're quite familiar with a series of cases that had arisen because of the oil crash last year. And oil in particular, it's very specialized and very nuanced for a variety of reasons. And one of the reasons is this use of a payment letter of indemnity. So typically, anyone in international trade would know that the bill of lading, the BL, is a key document used to give good title to somebody else, and it's used to trigger payment for most part as well. Oil is the only product I am aware of that uses a payment LOI under an LC. So an LC payment, meaning a bank makes payment on behalf of a trader, is done on two very simple documents, an LOI and an invoice. Why this is so, I still don't really have a good answer for it. The traders tell me that the speed of oil trade is done so quickly that it's just never realistic for BLs to catch up with the different traders. I can see sense in that, but that is equally true of other commodity product types as well. So when you're set in my position, when I'm doing commodities across the different product types, I can't quite see this as an oil particular reason. I'm also told, and this is my own hypothesis more than I'm being told, is the flow of the physical goods. So if we concentrate on the screen on the bottom left, on the bottom half of the screen, you have got the movement of the oil from a refinery or from a producer all the way to 2 or 3 traders and then back into storage again, storage or onwards to for onward use. The nature of oil trading requires trader 1 to pick up the cargo on an FOB basis and then deliver it on a DES basis. Ultimately, the person who's receiving the cargo only cares about receiving the cargo. They're not too, unlike CIF contracts and CFR contracts where you're dealing with the documents and the documents play a more prominent role. In the oil trade, when you're dealing on DAP and DES basis, meaning that the nature of the risk is meant to, the nature of the obligation is meant to move directly to the delivery point, there is less focus on the BL. And I suspect that's the reason why the BL never really features. In my mind, I think the BL stays with the refinery or with the producer in the first instance. It just stays there because they would say that BL is not needed for discharge. The discharge of the cargo can be done through another LOI mechanism known as the discharge LOI. which is a different mechanism from a payment LOI. But ultimately, this practice of using LOIs means that you decouple a very key concept of a BL. The BL is meant to not decouple, you nullify a very key concept of a BL. A BL is meant to give the rightful holder of the BL rights of possession. At any point of time, the rightful holder of the BL is able to go to the ship owner saying, Mr. Ship Owner, I am the owner of the goods, can you please give me possession of the goods? If the ship owner cannot get possession of the goods, that leads to a misdelivery claim and a whole bunch of lawsuits that will follow after. In the sequence of oil trading claims, one set of issues that have arisen has been this misdelivery issues, because the cargo is gone, the cargo has been used, consumed, and yet a bank might find that they're holding on to a BL, or a counterparty might find they're holding on to a BL, and then the counterparty doesn't have access to the cargo itself when it wants to liquidate the security. So that's one category of issues, legal issues that come from the oil trading mechanism. Another one comes from LCs and the use of LOI payments under LCs. And if you are with me for a second, in this LC flow chart, for example, just to work it through, Trader 2, who buys the oil from Trader 1, gets its bank to open an LC. Payment terms of the LC would be that once you present an LOI effectively an IOU, meaning that it's just a one-pager that says that Trader 1 has got good title and they will surrender the BL whenever it finds it, then payment will be released. That's where I stop for a second and say, let's put this in context. Out of two documents, by creating two documents, an LOI and an invoice, all of which could be done by a teenager in their back office, you can trigger payment of, I'm not talking about a few $1,000s over here, I'm talking about a few $1 million. I'm talking about large sums of money being traded on LC payments and being transferred off the back of some very loose documentation. This is a big danger. I think there are several cases going on in the court now where this is being fought about, because one of the traders in the string might become insolvent. For example, I put Trader 3 in the diagram. If Trader 3 becomes insolvent, then naturally the whole domino starts to kick on. The bank who is responsible, who's taken the credit risk on Trader 3, is not willing to get recovery from Trader 3. So it tries not to pay on Trader 2, or it does not want to pay out of fear of a variety of reasons. The big reason that has shaken the market, or shook the market last year, was the perpetual fear now that documents might have been forged. And so banks that are dealing traditionally on an LC mechanism have now started to question whether the payment that they're making might have been on a forged document. This is extremely tricky, and it's an area of law that I think is it's an area of law that is quite challenging to change the prevalent view. The prevalent view is this: an LC payment is meant to be as good as cash. That's how the wheels of international trade has been turning for centuries now, and it's for decades now, and that's where public policy dictates that when an LC payment is made or put forward, a bank stands behind it. A bank can only refuse to pay on an LC if the beneficiary, the person who's claiming on the LC, is guilty of fraud. So I stop there for a second. It is not the fraud it's not a third-party fraud that matters. It's not even the fraud of the buyer that matters. It is the fraud of the seller. The seller must be aware that when it presents the documents, it's doing so fraudulently. And that is notoriously difficult to show because you're going to the mindset or the knowledge of the seller himself. How is one to show that someone is aware of a fraud? It's a tricky one, and I think most people trying to challenge payments under an LC in this manner are going to find it an uphill task. That's one argument. The other argument on the counter side is quite logical as well. Why, as a bank, should I be paying for a trade that did not exist in the first place? Why should I pay on a fictitious document? If the document has been forged or is fictitious, even though it qualifies as an LOI or an invoice, why should I as a bank be paying for it? These are the two arguments that are being that I would imagine that will come to a head in dealing with LC payment claims. And the question here is whether there's enough latitude to allow effectively what might be deemed as a nullity exception. So I spoke about fraud, and fraud is an exception to LC payments. But as I stressed before, the fraud has to be that of the beneficiary, of the seller. And I've taken this fairly lengthy phrase over here and put it before you, and that comes from one of the old English cases dealing with payments under LCs. And the nub of it is that, yes, the UCP rules and the rules governing payments of LCs require that as long as conforming documents are provided, payment should be made. But that is on the assumption and on the fairly reasonable assumption that the documents are true and genuine. If the documents are null and void because they've been forged or fake, then as the clause reads, it defies reason and good sense to make payment on it. I've put this phrase out there as food for thought. The issue is still a finely poised one, and I think it's something that I look forward to receiving or to hearing what the courts in Singapore decide on. I'm briefly going to touch on what is now the hot button topic of invoice financing. Everyone has read the press about the issues that have risen from invoice financing in the past few weeks, and supply chain financing in particular. And I raise this because it is a very discernible pattern that appears from invoice financing. So in an invoice financing structure, it is pretty straightforward, pretty vanilla, that a seller sells his invoices to the funder. A notice of assignment is received from the buyer. The buyer says, yes, I owe you, the seller, this money, and I will pay this money now to the funder. Which the invoice and which the contract has been assigned to. So there is this joining of the dots, as you see over there. There's a triangle of relationships where the buyer acknowledges it needs to pay to the funder. Now, the key question I have over here is that this notice of assignment, the acknowledgement of assignment that the seller gives to the funder, where does that document come from? It comes from the seller. It is signed by the buyer. The buyer says, yes, I acknowledge that this invoice has been assigned, but that document passes through to the seller and onto the funder. When lawyers like us are used to engage, when we are used to be engaged to pursue this, when we go after the buyer on behalf of the funder, the buyer often says, no, I never signed the document. I've never signed this acknowledgement. Sometimes it's I've never even heard of the seller in the first place. This whole thing is forged. So the funder has paid to the seller for an invoice that was not tied to any trade. And this is where I come back to the starting point of the ease of which fraud can be done, particularly in documentary fraud where you're just issuing invoices. Naturally, there are a lot of mitigants that can be inbuilt into this structure. The funder should check with the buyer. The funder should get comfort and know that the buyer is liable for the payment that is assigning for. But in this nature of invoice financing, it is easy to talk about it now in isolation, in a one-off example. in the business model of invoice financing, you are dealing with hundreds, if not thousands, of invoices. And this is where the business model, the system, might not be tilted in a sufficient direction for the funder to independently verify with the buyer every bit of information. This, what I call this Achilles heel in how a very simple document can get past the gates. It's being addressed now by the code of conduct that the MAS and the Association of Banks in Singapore are advocating that banks use. And that code of conduct, one of the one of the recommendations is that assignments that are acknowledged be received from the lender directly from the buyer. Cut the risk of a forgery or reduce the risk of a forgery as much as possible. Another difficulty with assignments, and these are, well, sometimes you look at these issues and you think these are fairly commonsensical, is that once an invoice has been assigned and enforcement is sought of that invoice, the buyer may come with all sorts of excuses. The buyer may say, oh, no, there was a sale contract, but this was before we had an umbrella contract, a master contract, and some other money was owed to me as the buyer, so now I'm offsetting it. They might refer to some other terms and conditions somewhere in their relationship. There are all these nuances which are not, I don't think they're great arguments for a buyer to put forward, but they cause problems in the enforcement. If you are a lender and you're seeking to get back your money on what is a very simple exercise of collecting on an invoice, you might find that you might find yourself in a difficult situation of dealing with some of these nonsensical points, and particularly in jurisdictions that are hard to pursue. So you might have buyers in challenging jurisdictions, in Vietnam, in the Middle East, in India, of which if you come to a lawyer like myself and say, I would like to pursue legal means, I would be honest and tell you it's going to be challenging. I'm going to touch very briefly on the next few slides because we're running out of time. I've put over here a typical trade finance structure and how it tends to go wrong. And it goes wrong because of a concept of a pledge. Most trade finance structures, well, for import and export finance, there is often a concept of a pledge and a trust receipt. Now, a pledge is when you hold on to the physical asset. So, to give you a simple example, if I was to pledge my car to you, I would give you my car. Physically, I would pass the car to you, give you possession of the car, and that's why it's a pledge. You don't need to tell, nothing more needs to be done because you have possession of that asset, of that collateral. When it comes to BLs, however, pledging the BLs just isn't enough. It's not enough to take that document and give it to a bank because, as I've shown you in the slide before, the goods can move independently of the document. How do they move independently of the document? Through this market practices of LOI discharges and so on. I've put this is a very technical and somewhat boring slide to put before you, but I'm starting to talk more about security in the lending process. And I want to touch on it because in a restructuring context or in a recovery context, where you stand in the sliding scale of how secure you are matters. It matters in a restructuring, and so at the onboarding stage, at the structuring of the trade, that's where all these different forms of security needs to be considered carefully. I've touched briefly on pledges and how pledges actually needs to be a bit more thought out when it comes to international trade. I also have spoken about assignments and how there is a risk of multiple assignments. And then lastly, I want to now speak about charges and this notion of a fixed and floating charge that is almost consistently present in every facility agreement that I've seen. Just a few nuances about fixed charges and floating charges. What might be on paper a fixed charge may in practice be just a floating charge. if there is no control. Control is a key element for a fixed charge to be deemed a fixed charge, not what you write in the documents. And between two floating charges, there is a priority of competition as to whose charge comes first. And there's an issue of knowledge, of constructive knowledge. If a charge has been created subsequent to an earlier charge, then logically a party will be deemed to have constructive knowledge of the earlier charge and will take subject to that earlier charge, particularly if there's a negative pledge. I'm looking at my time now, and I think I've got 2 to 3 minutes, and I'm briefly going to go through restructuring in Singapore. I just wrote an article this morning for the Business Times on restructuring for commodities traders, and that might be a good resource to read about in terms of whether a restructuring plan might be worth it or not. But briefly speaking, let me give the two options, which for most lenders you'll be very familiar with. You've got three options effectively. You can go into liquidation in a scenario where your borrower doesn't pay. There is judicial management in the middle. That's when a third party steps into the shoes of the company and runs the company. That's typically when there's proprietary concerns over what the directors have done. And on the left, you've got a scheme of arrangement, which is the most, not the most, but it's a common way of restructuring because it allows the directors to keep charge of the company while the restructuring is being done. The restructuring process, it is a mechanical and systematic process as to how you move from one end to the other. There are certain steps that you can take during this process, but the key point that I want to put to creditors, in particular lenders when dealing with trade finance, is this slide over here, which I hope I can move. There we go. Okay. And the key point about restructuring is this, is that every restructuring plan I have seen consists of three main components. One is assets. A company would say, I need more time so that I can collect on my assets. And my assets for trading houses that have got no physical assets tends to be receivables. As I've just gone through in the past few minutes, receivables is a slippery notion. What is on paper and what is in reality can be two separate things. And it can be quite challenging to get $1 back from a $100 million receivable. So it's one thing to talk about receivables on paper, quite another to be able to get that money back. If the concept of restructuring a company is to allow the collection of receivables, this really needs to be considered and this really needs to be balanced out. Will a counterpart truly pay a company? What driver, what leverage does a debtor have over a counterpart to make it pay its receivables, particularly if the counterpart is in foreign jurisdictions? Point number one of a restructuring plan. Point number two is the business plan. I mean, the business plan tends to be, sometimes there isn't a business plan in the restructuring plan. The business plan is just to keep doing the same thing. That cannot possibly be the basis of which to restructure. There has to be, obviously, whatever has happened with the company has not worked. And so there has to be a change of direction, a change in focus, a change in strategy, a change of product type. For trading houses, for commodity trading houses that have got no assets, what can they truly, the business plan must involve the use of financing. The business plan must involve getting financing so that they can do more trades. And without confirmation of financing in the future, if lenders don't step up and say, yes, I'm willing to commit $10, $100 million banking lines to a borrower, what hope is there of a business plan working? The last point then is the capital injection that is often promised, but sometimes never materializes. Capital injection comes, there's a promise, there's this carrot of a white knight, some vague reference to a white knight somewhere that's going to appear out of the blue and save the company and pump in money into the company. This makes sense for a lot of businesses. For commodity trading houses, I think creditors should be more alive to the fact that why is a white knight pumping money into a trading house? What assets does it have? If a trading house effectively is just being a conduit of a trade, why would a white knight want to pump in that money? That objective needs to be, that driver needs to be tested continually, and these considerations needs to be continually in the minds of creditors, not at the end of the process, but at the start of the process. Right at the start, there are different hurdles by which a scheme needs to be approved, and creditors need to be constantly asking themselves, if not the debtor, these questions. I've come to the end of my slide, and I think I've got a good 10 minutes to take questions. If you give me a second, there's a whole list of questions to go through. I hope you found the presentation helpful. Just give me a few minutes while I try to tackle the easier questions and not the harder ones. Okay, I'll start with the bottom question first. That in a restructuring, does anyone verify the evidence that is submitted to the court other than the person wanting the restructuring? That's a very good question, and that's something that is not asked often enough. So in a restructuring process, what happens is that the debtors put up evidence to say, this is their position, this is why they need to restructure, and this is their plan. In the first instance, it's a broad plan, it's a broad strategy. The debtor is typically seeking for a moratorium. It just wants protection against any claims while it works on a restructuring plan. The questions that I ask in court myself for restructuring cases would be exactly that if receivables, if $100 million worth of receivables is truly said to be due and owing to the debtor, then where's the evidence behind it? It's not enough to have financial statements showing that. What needs to be tested is you need to get a lawyer's opinion in that jurisdiction to say this money is due and owing, is acknowledged by the buyer doesn't dispute that amount. And the key part then is about the recoverability of that money. You need an opinion as to how recoverable it is, because on paper it might look recoverable, but if you ask the lawyers in these countries, they would tell you it's an uphill task. And then all of a sudden, maybe that $100 million asset list gets a bit narrower. Let me take another question. Oh, this is a good one. The question is, in the case of an interpolated circle with a string, are copy BLs used, or must they be original documents? If copies are used, how does title pass around the circle? Good question. I still think this is, I'll give you my answer. And I'll qualify it to say that I don't think that you'd find a clear answer to this. But my answer is this. Title can only pass on passing of the original BLs. And the original BLs can only be with one person at one time. Yes, you can use copy BLs if that's what you've contractually agreed. But if a third party is holding on to your BL at the time you are doing the trade, then in my mind, that trade cannot have happened. It's either the case that you're using a copy BLs for the sake of convenience, but at all times, the original BLs were within your control or within the chain. It wasn't held by a third party. The moment it was held by a third party, I start scratching my head and I point to the slide of an actual and phantom trade, and I said, no, it starts looking more like that. Give me a few seconds while I read out the questions. I'm reading out this question. I think I know what it's asking. So the question is, has there been any successful case claims for banks against LOI issuers when BLs was not provided subsequently. The context is this, and I want to create the flow of how the claims happen. In movement of goods, when goods are discharged using a discharge LOI, then there is a misdelivery claim that is always hanging in the air because someone might have a BL, a bank might have a BL, and will seek to trigger claims on that BL. You'll bring that claim in the first instance to the ship owner because the ship owner is meant to surrender goods to anyone that has the BL. The ship owner has no defense to that and will just have to roll over and pay. In return, the ship owner gets an indemnity from its charterer. And the problem is often the case that the charterer is the one that has gone insolvent. So the charterer is no longer, the charterer or the buyer, one of them has gone insolvent. And so there's a weak link in the LOI chain. Everyone holds on to an LOI thinking, it's okay, I'm not taking the risk. Somebody else is giving me an indemnity. But if one person in that chain goes into insolvency, then all of a sudden, this mechanism of paying by LCs makes no sense. You pay for an LC so that you don't take a credit risk on your counterparty. But the moment you discharge using an LOI, you've reintroduced that concept of a credit risk. Another question I have would be, do you think electronic bills, when and if widely adopted, will significantly reduce the opportunities for fraud? This is another question that I get asked a lot, and I would say this. Electronic bills or e-bills have been around from before I entered law school. And I went into law school a long time ago. They have been around, and it's not a case of, the question really is, why hasn't it been adopted? Or why hasn't it been, why has it not got wide scale traction? And I think it's a question that has befuddled me, but I suspect many parts of the world, we might be set in a world that it may be different from other parts of the world that still take comfort and trust in paper documents. And the shipping business, I think, is stuck in inertia in that way. They still want to trade on paper documents. So I absolutely agree that the only way to solve trade fraud is digitalization of EPLs, of documents, of invoices. But I'm not too hopeful of when that will happen, bearing in mind that the technology has been there for years. I have a question here. It's broken in a few parts, but obviously from a credit insurer. What are the questions? What are the best ways to prevent ensuring potential fraudulent trades from a credit insurer's perspective? What are the crucial documents to request for? What are the warranties and conditions to impose? What questions to ask traders? Okay, I'm going to start with the third question. I think maybe the third question should answer everything. In my line of work, I'm often looking for the conduit trader, the trader who is not in the business of trading goods, the trader who's in the business of trading documents. How do I know who this trader is? How do I find him? A trader who does not know how long a voyage takes between Singapore and India, a trader that does not know what type of vessel is used to carry oil or what type of vessel is used to carry bulk commodities. By asking these questions to the traders during the onboarding process, you very quickly get a sense of whether this person truly is in the business of physical trade. If he's not in the business of physical trade, then the question is left open. What is the person doing? And then you get a sense of their business model. I'm not saying that that there isn't a marketplace for paper trading and so on. There certainly is. And in itself, I don't think there's anything wrong. But if you claim to be a physical trader and you do not know the business of physical trade, it looks a bit suspicious to me. I am looking at my time. I'm looking at the very long list of questions. I thank you for the questions. It's actually superb. I might try to answer them after the webinar, given that we've got 1 minute left on the clock. Okay, one of the questions asked was about double financing, where fabrication and companies collaborating with one another. Could you give an example of such a case where A, D, and H, and what has happened? Let me try to put it. I can give you many examples of it, but let me try to put it in a more broad manner. It seems to me that often you've got a trade being done. You've got a trade being done orchestrated by the subsidiary of another company. So you might have let's say a Chinese entity, and then you've got its local Singapore subsidiary. Local Singapore subsidiary is part of a chain. So the documents originate from the Chinese entity, goes to the local Singapore subsidiary, makes its way down into a circular trade, comes back out onto D and H. So the last party receiving that document is, let's say, the goods move to India. So it's an Indian entity over there. All of these entities are actually linked. When we do our investigations, we find that they're actually linked to one another. And that's where we uncover that the document trail goes into a bit of a black hole. So effectively, if you're selling from one party to another, it's meant to actually just end up, the documents must end up with one party. Why D and H must be in cahoots together is because you cannot have two parties showing up at the port asking for the same set of goods. That's when the whole thing will unravel. So somewhere along the fictitious chain, one of the parties is the end point. It's the goalpost of this flow of this musical flow of documents. And at this end point, they stop it there. It doesn't get passed on to somebody else. I think that's the best I can answer that for now. Guys, thank you for attending this webinar. I appreciate the many questions that you have. Let me try to answer them. I'm conscious of the time, and I don't want to cut over it. I very much appreciate your attention. If there's any more questions you have, feel free to email the IBF. You have my email address on this slide as well. Feel free to email me directly, and I will take it up with you guys. I see there are a lot of questions on circular trades, and I think that that might have to be a topic for a different day altogether. Thank you, everyone.